As you all know, the United States Supreme Court issued its decision in Janus versus ASME that government employees who have opted out of their unions should not be forced to pay union agency fees or fair share fees. And this ruling does not apply to private sector unions and employees. Janus is certainly a very important First Amendment victory for all government employees throughout the Commonwealth. This ruling helps to ensure that these vital employees have a choice to support unions that may not hold their own personal political beliefs. Specifically, the Supreme Court ruled that taking money from workers who did not affirmatively consent to fund this political activity violates their constitutional rights. Unions spend big money on political activity, and these fair share employees contribute quite a bit to this activity. And now political activity isn't just campaigns. Janus did hold that it's union activity, including wage, pension benefit, anything that is part of those contract negotiations. $114 million has been spent by public sector unions on politics over the last 10 years. These are the very unions who have opposed reforms of our woefully underfunded pension system. These are the very same unions who have worked to block popular changes to our state-owned liquor stores. And these are the very same unions who have stood in the way of job-promoting regulatory changes, often over the objection of government workers themselves. 28,000 Pennsylvanians who are workers here in the state pay fair share fees. Fair share costs these employees a collective $9.7 million just in 1 year. And that equals just shy of $350 per worker per year. My legislation, House Bill 2571, simply ensures that the law of the land is enforced here in Pennsylvania and that these government employees are made aware of their rights. Ultimately, House Bill 2571 is a consumer worker protection issue. House Bill 2571 would further protect the rights of individuals in a collective bargaining unit who are not members of the representative union, also known as those fair share payers. Specifically, the legislation proposes the following 4 changes to Act 195. First, it directs public sector unions to inform non-union members of the Janus decision and that these once required fair share fees to the union are now purely voluntary. These workers will also be informed that their employment status will not be affected if they do or do not decide to contribute on their own accord to the union. Second, the bill requires a public employer to notify job applicants that being a member of the representative union is not a condition of employment, and that as a non-member, they have no obligation to make any payments to the representative union. Third, the bill prohibits public employers from making any payroll deductions from wages of non-members and requires employees to make voluntary payments directly to that representative union. And this helps to ensure that those payments are purely voluntary and consented to by the employee. Finally, the bill repeals 2 Pennsylvania laws that authorized the payment of these fair share fees by non-members, Act 84 of 1988 and Act 15 of 1993. This will help to ensure that Pennsylvania law complies with the Janus decision and takes these unconstitutional laws off the books. House Bill 2571 represents a huge opportunity for us to expand worker freedom here in Pennsylvania, to protect our workers and their rights, and to foster fairness in our political system. Again, this is ultimately a consumer worker rights protection bill.